Title 2 Legal Separation, Article 55. A petition for legal separation may be filed on any of the following grounds. 1. Repeated physical violence or grossly abusive conduct directed against the petitioner, a common child, or a child of the petitioner. 2. Physical violence or moral pressure to compel the petitioner to change religious or political affiliation. 3. Attempt of respondent to corrupt or induce the petitioner, a common child, or a child of the petitioner to engage in prostitution or connivance in such corruption or inducement. 4. Final judgment sentencing the respondent to imprisonment of more than 6 years even if pardoned. 5. Drug addiction or habitual alcoholism of the respondent. 6. Lesbianism or homosexuality of the respondent. 7. Contracting by the respondent of a subsequent bigamous marriage whether in the Philippines or abroad. 8. Sexual infidelity or perversion. 9. Attempt by the respondent against the life of the petitioner. Or 10. Abandonment of petitioner by respondent without justifiable cause for more than 1 year. For purposes of this article, the term child shall include a child by nature or by adoption. Article 56. The petition for legal separation shall be denied on any of the following grounds. 1. Where the aggrieved party has condoned the offense or act complained of. 2. Where the aggrieved party has consented to the commission of the offense or act complained of. 3. Where there is connivance between the parties in the commission of the offense or act constituting the ground for legal separation. 4. Where both parties have given ground for legal separation. 5. Where there is collusion between the parties to obtain the decree of legal separation. Or 6. Where the action is barred by prescription. Article 57. An action for legal separation shall be filed within 5 years from the time of the occurrence of the cause. Article 58. An action for legal separation shall in no case be tried before 6 months shall have elapsed since the filing of the petition. Article 59. No legal separation may be decreed unless the court has taken steps toward the reconciliation of the spouses and is fully satisfied. Despite such efforts, that reconciliation is highly improbable. Article 60. No decree of legal separation shall be based upon a stipulation of facts or a confession of judgment. In any case, the court shall order the prosecuting attorney or fiscal assigned to it to take steps to prevent collusion between the parties and to take care that the evidence is not fabricated or suppressed. Article 61. After the filing of the petition for legal separation, the spouses shall be entitled to live separately from each other. The court, in the absence of a written agreement between the spouses, shall designate either of them or a third person to administer the absolute community or conjugal partnership property. The administrator, appointed by the court, shall have the same powers and duties as those of a guardian under the rules of court. Article 62. During the pendency of the action for legal separation, the provisions of Article 49 shall likewise apply to the support of the spouses and the custody and support of the common children. Article 63. The decree of legal separation shall have the following effects. 1. The spouses shall be entitled to live separately from each other, but the marriage bonds shall not be severed. 2. The absolute community or the conjugal partnership shall be dissolved and liquidated, but the offending spouse shall have no right to any share of the net profits earned by the absolute community or the conjugal partnership, which shall be forfeited in accordance with the provisions of Article 43, Paragraph 2. 3. The custody of the minor children shall be awarded to the innocent spouse, subject to the provisions of Article 213 of this Code. And 4. The offending spouse shall be disqualified from inheriting from the innocent spouse by intestate succession. Moreover, provisions in favor of the offending spouse made in the will of the innocent spouse shall be revoked by operation of law. Article 64. After the finality of the decree of legal separation, the innocent spouse may revoke the donations made by him or by her in favor of the offending spouse, as well as the designation of the latter as a beneficiary in any insurance policy, even if such designation be stipulated as irrevocable. The revocation of the donations shall be recorded in the registries of property in the places where the properties are located. Alienations, liens, and encumbrances registered in good faith before the recording of the complaint for revocation in the registries of property shall be respected. The revocation of or change in the designation of the insurance beneficiary shall take effect upon written notification thereof to the insured. The action to revoke the donation under this article must be brought within 5 years from the time the decree of legal separation has become final. Article 65. If the spouses should reconcile, a corresponding joint manifestation under oath duly signed by them shall be filed with the court in the same proceeding for legal separation. Article 66. The reconciliation referred to in the preceding article shall have the following consequences. 1. The legal separation proceedings, if still pending, shall thereby be terminated at whatever stage. And 2. The final decree of legal separation shall be set aside, but the separation of property and any forfeiture of the share of the guilty spouse already effected shall subsist, unless the spouses agree to revive their former property regime. The court's order containing the foregoing shall be recorded in the proper civil registries. Article 67. The agreement to revive the former property regime referred to in the preceding article shall be executed under oath and shall specify 1. The properties to be contributed anew to the restored regime. 2. Those to be retained as separated properties of each spouse. And 3. The names of all their known creditors, their addresses, and the amounts owing to each. The agreement of revival and the motion for its approval shall be filed with the court in the same proceeding for legal separation, with copies of both furnished to the creditors named therein. After due hearing, the court shall in its order take measures to protect the interest of creditors, and such order shall be recorded in the proper registries of properties. The recording of the order in the registries of property shall not prejudice any creditor not listed or not notified, unless the debtor's spouse has sufficient separate properties to satisfy the creditor's claim. Title 3. Rights and Obligations between Husband and Wife. Article 68. The husband and wife are obliged to live together, observe mutual love, respect, and fidelity, and render mutual help and support. Article 69. The husband and wife shall fix the family domicile. In case of disagreement, the court shall decide. The court may exempt one spouse from living with the other if the latter should live abroad or there are other valid and compelling reasons for the exemption. However, such exemption shall not apply if the same is not compatible with the solidarity of the family. Article 70. The spouses are jointly responsible for the support of the family. The expenses for such support and other conjugal obligations shall be paid from the community property, and in the absence thereof from the income or fruits of their separate properties. In case of insufficiency or absence of said income or fruits, such obligations shall be satisfied from their separate properties. Article 71. The management of the household shall be the right and duty of both spouses. The expenses for such management shall be paid in accordance with the provisions of Article 70. Article 72. When one of the spouses neglects his or her duties to the conjugal union or commits acts which tend to bring danger, dishonor, or injury to the other or to the family, the aggrieved party may apply to the court for relief. Article 73. Either spouse may exercise any legitimate profession, occupation, business, or activity without the consent of the other. The latter may object only on valid, serious, and moral grounds. In case of disagreement, the court shall decide whether or not 1. The objection is proper, and 2. Benefit has accrued to the family prior to the objection or thereafter. If the benefit accrued prior to the objection, the resulting obligation shall be enforced against the community property. If the benefit accrued thereafter, such obligation shall be enforced against the separate property of the spouse who has not obtained consent. The foregoing provisions shall not prejudice the rights of creditors who acted in good faith. Title 4. Property Relations between Husband and Wife. Chapter 1. General Provisions. Article 74. The property relations between husband and wife shall be governed in the following order. 1. By marriage settlements executed before the marriage. 2. By the provisions of this code. And 3. By the local customs. Article 75. The future spouses may in the marriage settlements agree upon the regime of absolute community, conjugal partnership of gains, complete separation of property, or any other regime. In the absence of marriage settlement or when the regime agreed upon is void, the system of absolute community of property as established in this code shall govern. Article 76. In order that any modification in the marriage settlements may be valid, it must be made before the celebration of the marriage, subject to the provisions of Articles 66, 67, 128, 135, and 136. Article 77. The marriage settlements and any modification thereof shall be in writing, signed by the parties, and executed before the celebration of the marriage. They shall not prejudice the third persons unless they are registered in the local civil registry where the marriage contract is recorded, as well as in the proper registries of property. Article 78. A minor who, according to law, may contract marriage may also execute his or her marriage settlements, but they shall be valid only if the persons designated in Article 14 to give consent to the marriage are made parties to the agreement, subject to the provisions of Title 9 of this Code. Article 79. For the validity of any marriage settlements executed by a person upon whom a sentence of civil interdiction has been pronounced, or who is subject to any other disability, it shall be indispensable for the guardian appointed by a competent court to be made a party thereto. Article 80. In the absence of a contrary stipulation in a marriage settlement, the property relations of the spouses shall be governed by Philippine laws, regardless of the place of the celebration of the marriage and their residence. This rule shall not apply: 1. Where both spouses are aliens; 2. With respect to the extrinsic validity of contracts affecting property not situated in the Philippines and executed in the country where the property is located; and 3. With respect to the extrinsic validity of contracts entered into the Philippines but affecting property situated in a foreign country, whose laws require different formalities for its extrinsic validity. Article 81. Everything stipulated in the settlements or contracts referred to in the preceding articles in consideration of a future marriage, including donations between the prospective spouses made therein, shall be rendered void if the marriage does not take place. However, stipulations that do not depend upon the celebration of the marriage shall be valid. Chapter 2. Donations by reason of marriage. Article 82. Donations by reason of marriage are those which are made before its celebration, in consideration of the same, and in favor of one or both of the future spouses. Article 83. These donations are governed by the rules on ordinary donations established in Title 3 of Book 3 of the Civil Code, insofar as they are not modified by the following articles. Article 84. If the future spouses agree upon a regime other than the absolute community of property, they cannot donate to each other in their marriage settlements more than 1/5 of their present property. Any excess shall be considered void. Donations of future property shall be governed by the provisions on the testamentary succession and the formalities of wills. Article 85. Donations by reason of marriage of property subject to encumbrances shall be valid. In case of foreclosure of the encumbrance and the property is sold for less than the total amount of the obligation secured, the donee shall not be liable for the deficiency. If the property is sold for more than the total amount of said obligation, the donee shall be entitled to the excess. Article 86. A donation by reason of marriage may be revoked by the donor in the following cases. 1. If the marriage is not celebrated or judicially declared void ab initio, except donations made in the marriage settlements, which shall be governed by Article 81. 2. When the marriage takes place without the consent of the parents or guardian as required by law. 3. When the marriage is annulled and the donee acted in bad faith. 4. Upon legal separation, the donee being the guilty spouse. 5. If it is with a resolutory condition and the condition is complied with. 6. When the donee has committed an act of ingratitude as specified with the provisions of the Civil Code on donations in general. Article 87. Every donation or grant of gratuitous advantage, direct or indirect, between the spouses during the marriage shall be void, except moderate gifts, which the spouses may give each other on the occasion of any family rejoicing. The prohibition shall also apply to persons living together as as husband and wife without a valid marriage. Chapter 3, System of Absolute Community, Section 1, General Provisions, Article 88. The absolute community of property between spouses shall commence at the precise moment that the marriage is celebrated. Any stipulation expressed or implied for the commencement of the community regime at any other time shall be void. Article 89. No waiver of rights, interests, shares, and effects of the absolute community of property during the marriage can be made, except in case of judicial separation of property. When the waiver takes place upon a judicial separation of property or after the marriage has been dissolved or annulled, the same shall appear in a public instrument and shall be recorded as provided in Article 77. The creditors of the spouses who made such waiver may petition the court to rescind the waiver to the extent of the amount sufficient to cover the amount of their credits. Article 90. The provisions on co-ownership shall apply to the absolute community of property between the spouses in all matters not provided for in this chapter. Section 2. What constitutes community property? Article 91. Unless otherwise provided in this chapter or in the marriage settlements, the community property shall consist of all the property owned by the spouses at the time of the celebration of the marriage or acquired thereafter. Article 92. The following shall be excluded from the community property. 1. Property acquired during the marriage by gratuitous title by either spouse, and the fruits as well as the income thereof, if any, unless it is expressly provided by the donor, testator, or grantor that they shall form part of the community property. 2. Property for personal and exclusive use of either spouse, however, jewelry shall form part of the community property. 3. Property acquired before the marriage by either spouse who has legitimate descendants by a former marriage, and the fruits as well as the income, if any, of such property. Article 93. Property acquired during the marriage is presumed to belong to the community unless it is proved that it is one of those excluded therefrom. Section 3. Charges upon and obligations of the absolute community. Article 94. The absolute community of property shall be liable for 1. The support of the spouses, their common children, the legitimate children of either spouse. However, the support of illegitimate children shall be governed by the provisions of this code on support. 2. All debts and obligations contracted during the marriage by the designated administrator spouse for the benefit of the community, or by both spouses or by one spouse with the consent of the other. 3. Debts and obligations contracted by either spouse without the consent of the other to the extent that the family may have been benefited. 4. All taxes, liens, charges, and expenses, including major or minor repairs upon the community property. 5. All taxes and expenses for mere preservation made during marriage upon the separate property of either spouse used by the family. 6. Expenses to enable either spouse to commence or complete a professional or vocational course or other activity for self-improvement. 7. Antenuptial debts of either spouse insofar as they have redounded to the benefit of the family. 8. The value of what is donated or promised by both spouses in favor of their common legitimate children for the exclusive purpose of commencing or completing a professional or vocational course or other activity for self-improvement. 9. Antenuptial debts of either spouse other than those falling under paragraph 7 of this article. The support of illegitimate children of either spouse and liabilities incurred by either spouse by reason of a crime or a quasi-delict in case of absence or insufficiency of the exclusive property of the debtor's spouse, the payment of which shall be considered as advances to be deducted from the share of the debtor's spouse upon liquidation of the community. And 10. Expenses of litigation between the spouses, unless the suit is found to be groundless. If the community property is insufficient to cover the foregoing liabilities, except those falling under paragraph 9, the spouses shall be solidarily liable for the unpaid balance with their separate properties. Article 95. Whatever may be lost during the marriage in any game of chance, betting, sweepstakes, or any other kind of gambling, whether permitted or prohibited by law, shall be borne by the loser and shall not be charged to the community, but any winnings therefrom shall form part of the community property. Section 4. Ownership, administration, enjoyment, and disposition of the community property. Article 96. The administration and enjoyment of the community property shall belong to both spouses jointly. In case of disagreement, the husband's decision shall prevail, subject to recourse to the court by the wife for a proper remedy, which must be availed of within 5 years from the date of the contract implementing such decision. In the event that one spouse is incapacitated or otherwise unable to participate in the administration of the common properties, the other spouse may assume sole powers of administration. These powers do not include the powers of disposition or encumbrance without the authority of the court or the written consent of the other spouse. In the absence of such authority or consent, the disposition or encumbrance shall be void. However, the transaction shall be construed as a continuing offer on the part of the consenting spouse and the third person, and may be perfected as a binding contract upon the acceptance by the other spouse or authorization by the court before the offer is withdrawn by either or both offerors. Article 97. Either spouse may dispose by will of his or her interest in the community property. Article 98. Neither spouse may donate any community property without the consent of the other. However, either spouse may, without the consent of the other, make moderate donations from the community property for charity or on occasions of family rejoicing or family distress.